And good afternoon. This is the meeting of the Appellate Advisory Committee, Appellate Rules Committee, Appellate Rules Advisory Committee. And thanks all for attending. I'm sorry again, this is virtual. Hopefully we'll all be together soon. And I appreciate your attendance both today, but also your attention to all of the issues that have been going on. A lot of folks have put a lot of work into this, into the rules we're going to be discussing today. Let's talk first about we have some new members. James Healy from Cowdery, I mentioned he's replacing Kathy Calaby on our committee, so welcome. Jennifer Bourne from the Public Defender's Office. Jennifer, I saw your initials. I don't see you on your screen, but congratulations on your new appointment. And I don't mean just to this committee, but generally. And Carl Cicchetti has just taken over as chief clerk here in this building. And congratulations to him, and he'll be replacing Carolyn Ziogas. Jennifer, of course, is here because of the retirement of Lauren Weisfeld. So welcome to all of you. James, we've had cases before. You're a James, right? Am I right? You go by James?
Yes, Your Honor. My father's Jimmy and his dad's Jim, so I've been called those variations as well. Thank you.
Jennifer, I've seen it both ways. Are you a Jen?
I am a Jen, yes.
You're a Jen. Okay, that's fine. And Carl, what is it, professor or doctor? Carl, which is it now?
I'm just going to go with Carl.
And so I don't think we necessarily need to go around the room, as it were. But I do note that we have Jeff Babin here from Wigan, Colleen Barnett from our appellate court. She's going to be keeping our record straight. And Colleen, you won't be shy about jumping in and asking who moved what, or, clarify, points of order or whatever you need to do. Jill Begeman, Jen Bourne, we just mentioned, Carl Cicchetti, Rich Emanuel is here. Paul Harton, as you all know, Emperor of all, here at 231. James Healy. Ken Barchi's here today for Wes. Is that right, Ken? Did I see your? I think I saw you.
That's right. Wes has an argument this afternoon.
Okay.
Next two.
Judge Huddleston's here, continuing her service on this committee. Many years as a practitioner and a judge. Claire Kindle's here from the Attorney General's office. Dan Krish is here from Halloran. Eric Levine, our reporter of judicial decisions. You're here, Eric, right? I think you're down as guest.
Yep, I'm here.
Okay, Bruce Lockwood, Chief State's Attorney's Office. Jesse Opinion, our staff attorney. Jamie Porter is not here. Charlie Ray from McCarter. Giovanna Weller from Carmody. Dave Gastigian, did I see you from our staff attorney's office?
I'm here, John.
Ton of work on this case, as well as Renee Robertson from the clerk's office. Dave and Renee, you're going to be hearing a lot from today. They've done a lot of work on this endeavor. I don't think I missed anyone, but tell me if I did. Okay, first item of business is approval of the minutes of October 27th, 2020. Those are pages 1 through 3 of what was distributed to you. You've had an opportunity to review them if you like. If there's no comments about them, a motion would be in order to get them approved.
So moved. Jeff Babin.
Oh, great. Yeah, do that. Could you, if you just, for Colleen's benefit, because not everybody's on the screen, just say who's seconding and moving.
Second, Claire Kindle.
All those in favor, say aye.
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 Any opposed? So that passes. We'll take up the first item then of a real business. 1B has to do with amending the rules regarding the filing of reply briefs. This is pages 4 to 6 of your handout. My understanding was that Dan, Krish, and or Jeff Babin were going to sort of lead this out or talk about its origin.
I will.
Yeah, Dan will take the lead, and I'm sure it'll be so complete I won't need to weigh in.
And if so, then folks who have or haven't been on this call, if you could raise your virtual hand if you have something you want to contribute, I will. And if you don't know how to do that, Paul will come to your office and raise it for you. No, and I will try my best to sort of recognize people in the order that you've raised your hands. If I'm not paying attention to the screen, maybe I'll take people out of order, but we'll all get along. So go ahead, Dan.
Thanks. And first, thanks to Jeff and to Carolyn Ziogas, who were my collaborators on the rule. I think the materials you have set out the changes, the impetus for it, as those of you at the last meeting know, is that there was this little lacuna in the rules about the timing of the reply brief when there are multiple appellees. We discussed that briefly at the last meeting, and then took the opportunity to draft a rule that addresses both that and reply briefs more generally, because there was not such a rule. The reply brief provision used to be one paragraph, or is still, but under the proposal will no longer be one paragraph in section 67-3. So this rule does not, or this proposal does not change a lot. It just clarifies the time for the filing of a reply brief where there are multiple appellees. It sets out the requirements for a reply brief in a separate rule rather than having it be part of 67-3. It makes a couple of changes to other rules, like 61-7, where the reply brief is mentioned and where there would be some conflict or confusion given the new rule. The only thing, and Jeff, I disagree with you, correct me if I'm wrong, only thing that is remotely new and substantive is that the reply brief now incorporates what is, I think, every good appellate practitioner's practice already in the court's off-state of preference, which is that reply briefs should respond succinctly, and forget the exact language that I used now, succinctly to arguments made in the appellee's brief. So that puts that in the rule as a guideline, as these things tend to be, as it is in some of the federal rules regarding reply briefs. I'm happy to entertain any questions, and I do just want to apologize for my, let's call it, very business casual appearance. As Jeff knows, I had a baby daughter last week, and so I'm home with her. And so otherwise I would not be unshaven and in a sweatshirt, but I've had about 2 hours of sleep the last week. And now I'm happy to take questions about the rule or let Jeff weigh in if there's anything I left out.
Anyone? Giovanna?
Yes, thank you, Your Honor. I think the rule is terrific. Dan, I just have a question. In 61-7, where you add in subsection C in a single consolidated reply brief, if any, further down in that paragraph, it says, if the parties cannot agree on the content of the brief and the appendix, then they can file a motion. I'm just wondering if there's a reason why it doesn't say, if the parties can't agree on the content of the brief, the appendix, or the reply brief.
Because I overlooked it, I think. Parties going to agree on the contents of the. Yes, I think that we should add that there as well, to make it consistent.
Super, thanks.
Okay. Charlie Ray.
Thank you, Your Honor. I just have a question on 67.5A, and it may not make a difference. If there are multiple appellees whose interests may not conjoin and they all file separate briefs, under the current rules, am I limited to a single reply brief, or am I entitled to file reply briefs in response, excuse me, separate reply briefs in response to each of the appellees' brief?
My understanding is the practice of the clerk's office, at least, if not the letter of the rule, is you got one reply brief.
Okay.
Even if 3 or 4 appellees filed their own briefs, you got one reply brief. And that's from Carolyn and Jeff, from Carolyn in our discussions with her and Jeff.
Carl, do you want to jump in on that? And maybe we work with people on that?
Yeah, that Jeff, sorry. Dan's correct. We the preference is for the one brief, and we can definitely work with people on that. Absolutely. I
guess, Charlie, the point being that we don't want to, start with, say there's 3 appellees, they all file. We don't want to start with sort of 45 pages of reply, but we get the point that maybe, is that where you're coming from, Carl, that 15 may not be enough? But it serves everybody better that it's all in one brief, and we do the best we can to keep the page limits down.
That's my understanding of what we're trying to accomplish here. Certainly, I think if there were a situation where there were 3 separate appellees briefs that were talking about 3 very separate things, there would, of course, there would be understanding that you may need some additional pages for that, and that we would, we could send those off to the court for approval for additional pages. I don't, we'd have to see what was going on with the request first, though. I can't promise any additional pages.
Okay, and if that's the case, then I have no comment on the proposed rule as it's written.
Okay. Good. Okay, Jeff.
Yes. Hi. So I just reiterate that the really the thrust of this rule was, as Dan said, to have a mention of the content of the reply brief, and in a succinct and direct way. And that's the words that, of course, are used directly and succinctly, because there already were rules with regard to the content of the appellant's brief and the appellee brief, and there was never any mention of the content of the reply brief. And so it's short, but now it's addressed. And there are now cross references to this where necessary elsewhere. So I think it makes it easier for people to find the reply brief. I'll mention that I have seen in rare occasions, and I think it's consistent with what Carl Cicchetti was just saying, that I have seen where somebody has moved and has filed separate reply briefs, but it does seem pretty rare. But obviously, it can happen if it's appropriate to the particular case, or somebody can get extra pages for a single reply brief if there are a lot of appellee briefs that raise different issues from each other as opposed to issues in common. So I think that goes to what Charlie Ray was saying, just from my own experience as a practitioner over the years and what I've seen. From what Giovanna was saying in terms of the reply brief on 61-7, where you have joint or consolidated appeals, are we thinking then that final sentence would say, if the parties cannot agree upon the contents of the brief and appendix or the reply brief, or if the issues, and then a comma, or if the issues to be briefed are not common to the joint parties, any party may file a motion for permission to file a separate brief and appendix or reply brief? Is that essentially what we would then do if we were going to alter it in that manner?
Yes, that sounds good to me, Joe.
Okay. That's all I have.
Claire?
I would reword that sentence differently. I would say the parties cannot agree upon the contents of the brief, comma, appendix, comma, and reply brief, comma, or if the issues to be briefed are not common to the joint parties, any party may file a motion for permission to file separate briefs and appendix. Or the last one could be file a separate brief, comma, reply brief, comma, and or appendix, however we wanted to do it.
This is Jeff. That sounds fine, although I tend not to like and/or in
Yeah.
writing or in a rule. It
I
could be,
agree. So
it could be,
so we
it could be,
probably get
yeah.
around that.
Okay.
Okay, so let's see if there are other comments, and then maybe whoever's keeping track of all the verbiage can make a motion with appropriate friendly amendments. Anybody else want to be heard on reply briefs? Judge Prescott, you good? Oh, who else we got here?
I am, yeah.
I just saw a hand go up, but I can't attribute it to anybody.
It's Renee, Your Honor.
Justice Doria.
Oh, sorry. Go ahead, Renee.
I would just note that if we're changing to word counts instead of pages counts, the locations in these rules where it references the 15-page limit would need to be adjusted to whatever's adopted as a word count. And I don't know when this rule would go into effect, but we would certainly want to make the word count instead of a page count at the time when the e-briefing rules go into effect. So just a note that we'll want to keep on our radar.
Okay, is that something, Eric, can I ask you, is that something you would end up taking care of, or should we get approval of some sort?
I guess the language would have to be approved in the first instance. So you're saying to redraft and then to go back to the committee, or?
I guess just, I thought I understood Renee to be saying it's just a question of keeping track where in the rules these are. Am I wrong about that?
Yeah, I just want to make sure, like I said, I'm not sure when each of these rules are going to go into effect. Like, are we going to have this new set of reply brief rules go into effect prior to when the e-briefing rules would go into effect? So we'll want to pay attention to that. But once the e-briefing rules do go into effect, we'll want to make sure that these new rules for reply briefs reflect a word count instead of a page number count.
I see.
So it's kind of two moving parts there.
Renee, I think that the intention is that this would all happen at the same time. So we'll have to make some cross-referencing, changes and make sure all the internal cross-references are accurate. But I see that as more kind of editorial than anything else. So.
Okay, sounds good.
Okay, anyone else want to be heard on reply briefs? Seeing none. Dan, what's your pleasure? You want to try to move this with the language you've added, or how do you want to do it?
I would move it with the language suggested by Claire. I don't know if Colleen noted down the language.
I would prefer for Claire to run that one more time. I had your language and didn't.
And remember also, Giovanna had a thing you had to add.
Yeah, I think Claire's edit is to incorporate Giovanna's suggestion. Excuse me.
This would be part of 61-7, sub C. And I believe Giovanna's was any appellee shall file a single consolidated brief, or if applicable, a single consolidated brief, comma, reply brief, and appendix as the second sentence. And then the third sentence would be the parties cannot agree upon the contents of the brief, comma, reply brief, and appendix, or if the issues to be briefed are not common to the joint parties, any party may file a motion for permission to file. I would simply say take out the and make it
Claire, I'm
separate.
sorry. I don't think there's a change to the second sentence. But appellees can't file a reply brief. So the second sentence is all appellees shall file a single consolidated brief, or if applicable, a single consolidated brief and appendix. That's the
So
second
what
sentence.
happens at the time of reply?
Oh, sorry, what happens if?
For the second sentence, then what happens for the reply brief?
There is no reply brief in the second sentence. Appellees don't file reply briefs.
Oh, I'm sorry. You're right. Never mind. Don't mind me. No.
It's just the third sentence, and I thought your language was perfect for that. So
It
if the
was,
parties,
and I was trying to be complete, and you're completely correct. I'm sorry. The third sentence is the parties can't agree to the contents of the brief, comma, reply brief, and appendix. So it's, and then at the very end of it says any party may file a motion for permission to file separate briefs and appendix, or you can do a separate brief, comma, reply brief, and appendix. Either way, I don't know.
and I would just edit if a friendly amendment to that to make the and or in those two things. So, sorry.
I agree.
Yeah. So contents of the brief, reply brief, or appendix if the parties cannot agree. And then in the any party may file clause, a separate brief, comma, reply brief, comma, or appendix.
Okay. How you doing, Colleen, on that? Good? Terrific.
Great.
So thank you.
As amended, I would move approval, move for approval.
Okay. Attorney Krish with a motion. Do we have a second?
Second from Jeff Babin.
Okay. All those in favor, say aye.
Aye.
Any opposed? Okay, that passes. We'll move on to 1C of our agenda. Amending the rules to require the filing of electronic briefs. Now, obviously, this is something we've been talking a lot about for a fairly long time. We're getting closer to e-briefs becoming an actuality. A lot of work has been done, not just on the rules themselves, but sort of investigating and determining what shape, this is what shape this is all going to take, and what the technology is going to be that is required. We've had committees and subcommittees and within the branch, and had input from a number of you practitioners. So now we're at a point where this is really ready to have a discussion with this committee about implementing rules. We'd be looking towards adopting proposed rules to go to a public hearing, hopefully in May, getting the rules to the two courts for approval in the spring or summer to be effective in the fall. All of that we'll talk about. So what I'd like to do is go through the rules sort of in groups. This sort of lends itself to, I see sort of four groups, four groups of rules, and I'll describe that as we go along. The first group of rules is going to be concerned what we're referring to as the party appendix, party appendices. Before we delve into that, Judge Prescott, anything you want to mention before we sort of go group by group?
No, I think that's fine. That makes sense.
Okay. So the first group is, as I said, is referred to as the party appendix. That's for the most part covered by the first three rules under that heading: 67.1, 67.8, 67.2A, pages 7 through 13 of your materials. Renee Robertson has done most of the work on that from our side. Renee, do you want to walk this out a little bit? And then we'll take comments from the floor.
Absolutely. So I'll just go through each of them in the order that they appear in the documents we received. I will let you know I'm at home with just my one single screen laptop, so I can't see all of your beautiful faces. So if I'm not seeing your hand raised and you have a question, by all means, please someone interrupt me. Okay, so we'll start with 67.1. So the only substantive change here is, and it's not really to do with the appendix, but it's very simple. In the second paragraph, the way the rule previously read was that the statement of issues should be contained on, should be no longer than 1 page in length and should be on a page by itself. And in order to capture both of the people who are going to continue to be paper filers and to accommodate the new e-briefing rules, we basically just shortened that second sentence to simply read that the statement of issues should be on 1 page by itself. So that is the only change in 67.1, aside from adding the word "the" in front of the appellant in the first paragraph.
Renee, I should have mentioned this in opening this up. It may be obvious to some of you, but maybe not all of you, that what's driving the fact that we're splitting up these appendices, party appendix, and what we're now going to refer to as the clerk's appendix, which for those of us old enough, it's sort of replacing the yellow printed record, is we're trying to obviate the need. We're trying to work with you all so that we need fewer hyperlinks within the document. It would be a great benefit to the court to be able to hyperlink to certain things as we're reading along, given that we're going to be all on tablets and what have you. But some documents, perhaps the repetitiveness of them or the how often you're going to need to cite to them, it lends itself to sort of returning to the old regime of having a court document that has everything in it. So I don't know if everybody knew that, but so let me just mention that up front. So go ahead, Renee. So this is the party's appendix, not driven by the clerk's office.
Right, so we'll move on to page 8, which is the beginning of that party appendix section. All right, so I guess that I don't know if we want to really go through, I'm not sure how much time you all have had to review these proposals in advance of the meeting, but I don't necessarily want to go through every detailed change, but to kind of give an overview and then go through each of the sections. So as Justice Doria was just talking about, we're going to move to the clerks preparing a clerk's appendix, which is going to be very much like the old yellow covered record. And then each of the parties, the appellant and the appellee, would not be required to file an appendix, but they would have the option of filing an appendix for certain items that we would normally now put into an appendix part 2, like transcript, excerpts, unpublished opinions, and other trial court filings that the party feels are necessary to include, but aren't necessarily falling into the section of required documents. So that's what the party appendix is going to include. So a lot of these changes are just switching it up to call it a party appendix. At the beginning part of subsection A, that's where it discusses the inclusion of excerpts of transcripts. It keeps the requirement that you include the cover page and the certification page of those transcript excerpts. You can also do excerpts of exhibits into the party appendix. We don't want duplication, and you don't want to reproduce lengthy portions of transcripts or exhibits. That is a carryover from the current version, also has similar language in the current rule. Let's see. And then there is a note at the bottom of that opening paragraph of subsection A that indicates any documents that the party includes in their optional party appendix that they also have citations to in their brief, they'll be required to include hyperlinks. So that's what that portion is there. And I'm going to go on to the next page. Oh, I see Attorney Ray.
Yes, I don't know whether you wanted comments as we go along, or should we make comments at the end? How do you want to handle that?
Why don't we let Renee just sort of finish going through the sections, and then I think we can take sort of general comments. So you're first in the queue, Charlie.
That's fine.
If I can just ask, since Colleen is our keeper of the notes, would you prefer, Colleen, if I stop after each overall section, like if I stop after 67-8 to see if we have comments, or to do all of them and then get all the comments at once, which is easier for your note-taking purposes?
I believe that Justice Jory said he was doing these in the groups, so why don't we do it at the end of this group of part?
After 2A, after 67-2A.
Okay. All right, so I am on to the next page. All right, so again, a lot of this is holdover from what is currently in the rules. For example, in the middle of the subsection B, the opening paragraph, including copies of constitutional provisions, statutes, and things of that nature. And then in subsection C, this is partly about redaction and other personal identifying information that may be included in an appendix. And then on to 67-2A. So this is where we're going to start to get into some heavy changes. This is for formatting of the new electronic briefs. And so we're going to, because we are still going to have paper filers, we are going to continue to require at the top of the cover page a statement that it was filed under the electronic briefing rules. So that way it's easy to quickly notice what it is you're looking at, especially when the couple of paper copies come in. And then further down in the opening paragraph is another statement indicating that internal hyperlinks will be required when documents that are cited to in the brief are included in the party's optional appendix. External hyperlinks are not permitted. That's the way the rule currently reads, or it's currently a prohibition. We are allowing for visual aids to start to be added to these briefs. And we will have, because it's a new process and it may be, there may be a few changes as we see how it works, we will have guidelines posted on the Judicial Branch website in the same place where you can find other, information for appellate stuff that will help you out with the various rules regarding visual aids and using those. In subsection B, we have an update to a new fonts, and we're also going to require them to be in 12-point font, not 12-point or larger. We want to keep them pretty uniform. So it'll be 12-point, and we've got the new font selections here. The headings are to be in different fonts, and so we've given you two options for those. Part of the reason for giving you two options for both types of fonts is because not everything is available in Microsoft Word. And it depends on what word processing software you're using as to what is available to you. So of the substantive portion of the brief that requires Century Schoolbook or New Century Schoolbook, we checked and at least one of those is available in Microsoft Word, and the same for the headings. Georgia, I believe, is available in Microsoft Word. Margins, they're going to be 1.5 inches on all sides. So you're not going to have the difference of, the left hand coming in further to account for binding. So it's going to be uniform margins all the way around the 4 sides of the document. Left aligned text, no justified text, just makes it easier to read, to do left aligned. A lot of this stuff is based on studies, for those of you who haven't had previous meetings, based on studies about readability. So that's where a lot of this, the background of this came from. For line spacing, it'll be 1.3. So instead of double spacing your text, you'll do 1.3. And that's going to be the same everywhere. Body of the document, footnotes, block quotes, everything will all be 1.3. We'd like you to not use underlining. We're going to go to using bold or italic emphasis tools, and to have the sections numbered, but it doesn't have to be numbers. So that's why I've chosen the language of being marked sequentially. So you can put your brief in and sequentially mark the sections in some sort of an outline format, you know, so as it's the examples show here. For C, we're going to move to a single pagination scheme. So if any of you have done the optional e-briefing program, you've seen this, where starting with the cover of the brief all the way through to the last page of either the brief or an optional appendix, you're going to start at page 1 and end at whatever page. So even the cover will have a page number on it, and you'll indicate the total number of pages. So like, you know, if you're reading a document in Adobe Reader, you can look at the top, and like right now I'm looking at the materials and I'm on page 11 of 40. So at the bottom of the page, it would say page 11 of 40. So we're going to do that new pagination scheme. And there's an example of it at the top of the next page. The section about doing an index of the names of witnesses, that's a holdover from what's just required in the current rules. On to D for the paper copies. We're only going to require 2 legible paper copies of the brief and appendix. It's no longer going to be required that you have any particular type of binding, as long as they're securely bound. If your brief and optional appendix are small enough that you can just stick a staple in the top left-hand corner, that will be sufficient. So as long as you cannot take the paper copies apart, they can't easily fall apart, so still securely bound, that will be fine however you choose to do it. And we also, the language about being able to print your appendix on both sides of the page is a holdover from the current rules. Also, whether or not they can be bound together is a holdover, but we pared it down to just saying you can bind them together or separately without any specific details. For the next section, most of this is the same kind of information on the front cover as far as the name of the case and docket numbers and counsel information. So much of that is the same. On to the next page and the beginning of, I'm sorry, my copy is kind of faded, so I can't tell what letter I'm looking at.
Top of that page is J.
Is that a J? Okay,
Or-
the next one's G, so I was wondering, that might be a typo.
It should be an F.
Yeah, should be.
Okay.
You're right.
Yeah, because that becomes before G. So this is also not really anything new, because you're going to submit the electronic version of the brief before you actually give us the 2 paper copies. The next section, G, this is going to be your certifications. There are some updates to these to account for the fact that they're going to be electronic briefs. So we're going to expect you to email them just like we do now. There's an additional certification for the word count, and I believe, and whether or not you got any approved deviations. So other than that, the remainder of the certifications are fairly the same. And then in H, this is the same as it is now. I believe it's a different letter, but it's the same as it is now, that you give us a copy of the electronic confirmation when you give us the paper copies of the brief. I, this is spells out how to request a deviation. So under our current rules, if you would like additional pages in your brief, you would submit that as a request. You know, just letter format is fine, indicating why you want additional pages and how many you want. This will be done in the same fashion, and you just be requesting whatever deviation from the rules that you're seeking. And is that where you wanted to stop, Justice Joria?
Yeah, I think it is. And before we'll open it up and start with Charlie, but one thing I do want to mention is I appreciate everybody bearing with us, well, through all of this. Certainly there'll be some bumps, but I think it will be better for all of us. But we would love to say that there's going to be 0 paper copies. And this is just right now the best we can do for and get this through our courts. So bear with us. Hopefully this will not be for too long, and we understand that doesn't solve everybody's problems, but that's kind of where we are. But Charlie, you had something you wanted to start with?
And Justice Story, I want to add on to what you just said, that the paper copies are going to be look just like the electronic briefs you're filing. They don't need to be, sent to Brescia or bound in any different manner than the electronic brief would look.
That's a good point. I mean, so, the state agencies, especially, I won't get into how you do it, but, nobody's, you might be still in a position where you can cancel your contracts or not renew them or that kind of thing. We just need we do need something in hand, and hopefully won't need to do that forever. Okay, Charlie?
Sure. Thank you, Your Honor. My compliments to whoever came up with these. They're very well written and very understandable. I have 2 comments on 67-8. The first is in regard to the second sentence, and my suggestion would be to separate out either with semicolons or by numbering perhaps all the different aspects of what could be put in an appendix. And I guess my preference would be an appendix may be used to : 1, excerpt lengthy exhibits, et cetera, et cetera. It took me a while to get through this sentence to figure out what it was that was going on here. And so I think if the different things could be separated out, it'd be a little more user-friendly and easier to understand. And then my second comment, about 2/3 of the way down on page 8, there's a sentence which evidently is in the rules now, and I had never focused on it before, but it says, if the filing of any party appendix is indicated, all materials must be included in a single appendix. And my comment is, number 1, I'm not sure what that means. Number 2, I'm not sure that it adds anything. And number 3, my suggestion would be that we just delete it.
Okay, Renee, or Paul or Jill, anybody?
I will comment first on the opening paragraph in subsection A about turning that kind of a long meandering sentence into basically a numbered list of things that can be included in a party appendix. I love that idea. So if we would like to do, if everybody agrees, I like lists and numbers, and it's very easy to organize that way. So I would definitely second adding that to the rule. And then for the second part, it is part of the current rule, and it is worded oddly. So I think that we definitely want to make sure, particularly because practitioners are so used to us having an appendix part 1 and an appendix part 2 and thinking of them as 2 separate items, that we want to be sure people know that you're giving us, there aren't going to be multiple volumes of appendix. You're going to, I mean, if it's huge and it ends up being printed that way, that's one thing, but this is going to be a single upload. So we're wanting to make sure we can drive home that this isn't something that's going to be parsed into different parts. But I agree that I don't know that we necessarily need that sentence, but I will defer to anyone who thinks we may be able to, we may need to keep it, or if we should get rid of it.
Well, it will create problems for hypertext linking if it's not all one document. So I think part of the concern was just making clear that it's only going to work in this manner.
If I may, perhaps then all materials included in a party appendix must be included in a single appendix.
I would note that we do have, I can't remember which section it is in, it might even be this section, or in 67-2A. We do have a sentence in the rule that indicates that the brief and appendix must be uploaded together as a single text searchable document. So I would definitely understand wanting to keep a similar maybe we put a sentence similar to that in this appendix rule instead of the one that says if an appendix is indicated, et cetera, et cetera. Because we do want to emphasize that this needs to be a single text searchable uploaded document.
Okay. Anything else before we move on to some?
It looks like Jeff and Ken might have their hands up.
Yeah, I did. Yeah, why don't we say Jeff and then Ken?
Okay, thank you. Second Charlie's positive comments about how well this is done. So, but obviously in something this new and long, there's always a few questions that arise. One, let me just ask what we were just talking about with everything being a single upload. Is there a megabyte limit then to what that upload would be, and what happens if one exceeds that limit, particularly if you have something in color in an appendix or something of that nature?
Anyone know?
Go ahead, Carl.
Currently, there is a 50 megabyte limit. We've mentioned to IT that we may need to increase that, and we have constant meetings with them, so that could be adjusted. If you couldn't upload it as a single document, if the document is that large, part of it might be how you've produced the document. A text document, even with some images in it, should be well under the 50 page limit, or excuse me, 50 megabyte limit. So it may be something you can do on your end to reduce that. Certainly if you split it in half, that destroys what we're trying to do. So we would definitely need, we are currently addressing that, but we would work with you and help you reduce the size of your document to the best that we can. It's somewhat software dependent on the user end.
Yeah. I mean, we do, not everyone, but it's certainly commercially available. I mean, we have specialized software where you can actually choose to both there's like an optimize and a reduce command, and the two of them can sometimes work wonders. Not everyone, of course, who's filing things are necessarily are aware of that kind of software, but it's certainly available. This is just one question I have. Obviously, this is done with the sort of normal showing of deletions and additions, but just so I understand, this is actually, it looks to me like a markup of the rule from years ago, not the current rule for appendix in 67-8, because the current rules on appendix 67-8 talk about part 1, part 2. So it looks right. So you essentially went back to the old rule that existed before the part 1 and part 2 and marked it up, and that's just for our own internal benefit. Obviously, when it gets submitted, for publication, it would show something. It would almost be like a new rule, and the old one is deleted, because I'm just trying to understand.
Use, the old rule from prior to the appendix part 1 and appendix part 2 as a template. So we may have to change the way it looks when we actually do the publication. But we did use the old rule as a template. So that's why it'll show additions when it's items that are already in the rule as it reads right now. So yes, you are correct.
All right. I'm just understanding that. In terms of subsection C, which is at the bottom of page 9 of our packet, which deals with personal identifying information and sealed documents. I was a little puzzled by the wording in this for this reason. It basically says that for all appeals that contain this type of personal identifying information, whether it's protected by statute or rule, or that's been sealed in part, shall be prepared in accordance with 67.2 or 67.2a. So when I read that, I think, well, if I look at 67.2 or 67.2a, it will tell me how to prepare the brief, how to seal it, how to redact it. But when I look at those rules, those are just the general formatting rules, and includes, unless I'm missing something, the only thing in there about redactions is that you include in the certification page that you have in fact redacted. But there's nothing substantive in those rules. And in fact, all briefs have to be prepared in accordance to 67.2 or 67.2a, not just those with this type of protected information. So I was a little concerned that the reader may not understand substantively what it is that we're being directed to do. And therefore, I was also thinking that perhaps the rule should, in fact, say, instead of prepared in accordance with those general rules, which are applicable to all briefs, not just these types of briefs, that maybe it should simply say, all briefs and party appendices shall protect personal identifying information as defined by 4-7, or other information protected by rule, statute, or case law, and shall comply with section 77-2 for appeals that have been ordered sealed in part or in their entirety or subject to limited disclosure. And then it's an affirmative statement that you have to protect this information. Because right now, I don't see any rule that actually says you have to do it. If I'm making sense.
We had a conversation about this as well, and that's taken from the current rule. We just added the section 67.2a portion to the end. And I believe that it was either Jill or Paul had a conversation about the origins of this addition, so they may be able to provide additional insight.
I believe we looked, and I couldn't find anything where that came from, other than the fact that it was clearly put in to the rules several years ago. Paul, do you have a recollection? Did we any more than that?
No, I don't. But I mean, based, what Jeff had said seems like a reasonable change to me. I mean, I think it offered better guidance as to exactly what the intent of C is. So I think my guess is we probably included this language because we probably ran into some problems at some point, and we wanted to probably emphasize the need to protect this information. And my guess is it was probably when we moved into electronic filings on some level. So I can't say for certain, though, but I think Jeff's proposal makes sense to me.
I agree with Paul and with Jeff, because the work group did kind of talk about that very language and try to determine the origin of it, and we couldn't, so we left it there because it had been requested before, but we couldn't pinpoint the origin of it, and I think that Jeff's suggestion improves it.
Okay.
Could I have Jeff repeat his suggestion one time?
Sure. So
let's see.
Yes. So this would be, in subsection C of 67-8. So you would take out the word for appeals containing, those 3 words, and instead say all briefs and party appendices shall protect. You may want to, obviously, whatever nice language that is your standard language, but that's just what I came up with. And then it would go on with what you have already there. So shall protect personal identifying information as defined by section 4-7 or other information protected by rule, statute, court, order, and case law. And then I would add, there's the word and right there. And after the word and, I would take out the word in, and instead I would say, and comply with section 77-2 for, the word for, F-O-R, and then continue with what you have. For appeals that have been ordered, sealed in part or in their entirety, or are subject to limited disclosure, period. And the period would come after disclosure. I didn't go back to 77-2, which I should have.
All right, so we're good. You good with that, Colleen? All right, Ken Barchi.
Thank you, Your Honor. So just picking up on that point, I know that in the practice has been, well, right now when you file your brief, you file your appendix electronically separately. And for family appeals, at least, those are never available to anybody who doesn't have an appearance in the file online. And the reason for that is the dependencies often contain personally identifying information, often the birth date of children. If it's a dissolution case, there may be tax returns in an appendix or something like that. So I think there's been concern just generally that things might slip through. And I'm wondering if there's any procedure that the clerk's office is going to, since this is all going to be available now, anything that the clerk's office will be doing to try to make sure that that information is still protected in case, it doesn't, whoever files the brief and appendix doesn't catch all the things they need to catch.
Paul, I think we had a conversation about this recently. Didn't you? You want to speak to that?
Yeah, we did. I mean, the expectation is that that council is going to get it right. In these situations, we're trying to obviously maintain the transparency that we can. So we're hopeful as far as whether we have additional measures in place in terms of review by the clerk's office. That was not, it's not really the intent. Ken, so I think right now we're hopeful that council will be efficient in protecting this information. I'm not sure there's a way around it.
And Ken, just as in the trial court, often it's the other side that points out something is in a pleading or a memo that shouldn't be there, and then there's the procedures to get it out and get a new copy filed. So I think we'd be looking for that.
Okay, just
I think that's right. I mean, we can't at all think that the clerk's office is going to be able to vet this stuff, or even if they did, everybody's human, stuff slips by. But this happens in the trial court too. I mean, this is not unique to our filing. So we've been e-filing in the trial court for years, and I take it that sometimes things need to be corrected.
Thank you. And then I had a couple of questions on page 10 regarding the formatting. In subsection B, you have line spacing as 1.3 times, and I fooled around on Word and couldn't figure out how to set that. So I'm not sure what you mean by that. Under the current rules, it's fully double spaced, which is defined as I think three double spaced lines per inch or some. There's a way that you can get to the result with your word processing system. So I wonder if there's a way of defining what you mean by that, or it's because I was just sort of confused about how you would do that. And then the other question is, if you're talking about numbering sections sequentially, can that include sub parts? So you have your argument, and then you have your first issue, and then sub parts to that, which maybe one and then A and B, C. Is that what you're contemplating? Because I sort of read it as just being everything has to be 1, 2, 3, 4, 5, or A, B, C, D.
I think that if I could, this is Renee. I think the intention is at minimum to get the overall sections numbered as is given in the example, like your introduction, your statement of facts, your procedural history, your argument section, conclusion. If you want to go further and split it out more into kind of like an outline format, so maybe your arguments in 3 sections that's fine. That's absolutely acceptable. But at minimum, we want those major sections delineated in some fashion.
Does that answer it, Ken?
Well, that's answers the one, but then the other thing is that the line spacing issue definition.
Ken, this is Dan Krish. There's a way in your formatting of paragraphs to choose any multiple between at least 1 and 3 down to 2 decimal places. So you can set it at 1.15, 1.30, and it's in the same paragraph settings that you would normally use, but you could choose that as an option and then set it to 1.3.
So it's the multiple is what you have to choose then, and then
Yes.
set it and then manuscript in what you want. Okay.
I believe right now it actually offers 1.15 as a default option because that's sort of readable on screen. But yes, if you want 1.3, you have to set it yourself.
Claire?
I was also going to offer the multiple setting in the paragraphs to show, because I was trying to figure out how you do the 1.3. I noticed that there was a change in the headings, and I just say that was great. I think that being able to initial cap your headings is a good thing. And the one question I have for the group, and this has been discussed earlier, is why 1.3 for footnotes and for block quotes? Is it because I realize 1.3 is supposed to be the optimal reading spacing for online reading, but it looks very funky having it. I mean, now, we could do something radical and just eliminate all block quotes, and that might improve the quality of briefing or make it worse, who knows? But why 1.3 for footnotes and block quotes?
So I know that one of the things from the studies that Carolyn had put together was that having uniform spacing throughout the entire document for all portions of the page was considered ideal. I'm not sure if perhaps Carolyn more specifically discussed those studies with Paul or Jill or Carl, and they might be able to give more insight. But I remember that being a point of discussion, that the studies had shown that uniform spacing throughout the full page was considered ideal. So that's why we went with the same spacing for everything.
Right. This is Paul. That's exactly right. Claire, that's really it. It's just readability studies. We went over this with folks through ITD, and there was really nothing more to it than the ease to read at that spacing.
Okay. For the most part, while I think this e-brief stuff is wonderful, and I think that the committee's done a tremendous job, but looking at e-briefs that have been filed, it just looks so funky with that spacing for the block quotes and the footnotes, and so it's saying, okay, well, I suppose so. I wish I could say that it would eliminate people's block quotes, but I don't think it's going to do that. So, okay.
Yeah, well, we'll see if the end users all feel like this is more readable, or if there are tweaks to it. We might be checking in on that. Not everybody's going to feel the same way. All right, well, if there's no other comments about that group, why don't we turn to the next couple? Am I right? Is no other questions? 67-3A and 7A.
I think Jill has a question.
Oh, sorry, Jill.
I'm trying to get my hand up.
Okay.
I just want to go back very quickly because I don't know if we reached a conclusion on Charlie's question on that sentence on page 8 about the appendix being, if filing of any party appendix is indicated, all material must be included in a single appendix. We talked about it back and forth. Colleen, did you get a resolution on that?
I believe that the resolution was left open. You are correct. Renee had made a comment about trying to import a sentence from another section, but I don't believe we had a final on that.
So I'm looking at, I looked at the sentence again while there were some other questions being asked. And of course my remote connection is disconnecting right now. I think we may be able to eliminate the sentence. We do talk in other sections about how the brief and appendix need to be a single upload, which to me would indicate that you're not having separate appendices. You may want to parse it out between different sections, but I think that we may be able to delete the sentence if we.
Why don't we do this?
We could reiterate that the brief and appendix need to be uploaded together as a single text searchable document, and just have the same sentence here as it appears in one of the other sections. But we do cover it in another section, so I think we could delete it, or maybe duplicate the sentence instead of having this one.
Okay. Why don't we, while we move on to the next couple sections, Renee, maybe if you get your connection back, or if you want to just go over that sentence again, we can come back to it at the end, and you can suggest, or others can suggest, whether we should strike the sentence or leave it for now when we try to move adoption of any of this. Sound good? All right, so section 67.3A and 7A, this is pages 13 to 17, thereabouts, of your materials. This mostly focuses on word count. Uh-oh, did I go somewhere? Can everybody still see me, hear me?
I can hear you. Renee, are you sharing your screen?
Like screen sharing.
Somebody
right now.
share your screen.
Did not mean to do that. Something happened. I'm sorry.
It's all right.
What is happening?
Are we sure we're ready for electronic briefing? So.
I think that's a very valid question.
All right, don't worry about it, Renee. You just knock it down when you can. I'll just go on. The trial, we had obviously the big issue here is that when we did the sort of pilot program here, we had 14,000 words. We're going from a page limitation with all the things that go along with that, single spacing, footnotes, single spaced, and lines per page, to a strict hard word count, and trying to arrive at what is the ideal number is a bit challenging. We have, on this proposal, we've knocked that down to 13,000 words. And there is an error on the appellees. We're not giving appellees more, if anybody picked up on that. It says appellees 14,000, but it should both be 13,000. The state would probably love that, Bruce. Is that what? No, you wouldn't want. You don't want the extra. You don't want the extra words. But we and so we've done some spade work on this. It seems like there will be some, those people who, optimize 27 lines a page, a lot of single spacing, a lot of footnotes. It's going to be challenging, but we've also found that there are a number of briefs, many 35-page briefs that come in under 13,000 with some regularity. So we're trying to come up with the right number, and we thought 13 was about right. Before I open it up, turn it over to Paul or Carl, Judge Prescott, you have anything you want to say about that?
No, and part of the 13,000 is driven by, the volume, particularly here at the appellate court. We typically, as judges, sit on, 18 to 21 cases a term. And so what we didn't want to do is expand the briefs beyond what they are now. And there was concern about if we could go much higher than 13,000, that we're actually going to be increasing the size. And that would be tough for the judges here.
I will tell you, this is Paul, I will tell you, and the credit goes to Carl. He did an awful lot of work on this. We worked very hard on this to try to give Justice Story and Judge Prescott good information and trying to come up with the right number or the best number that would work for everybody. I know some of you, the private practitioners on this committee, were involved with that. I don't have much more to say about it. I will tell you that we did spend an awful lot of time trying to make sure that we did a good job, and we did get good information to the co-chairs.
So anybody want to be heard on those? Carl, you have anything to say on that?
I don't have anything to add to what Paul said. We analyzed quite a few briefs, and I feel confident in the numbers that we provided to the court.
Yeah, as I say, it's not easy to transition to. I mean, I remember when we went, when the Second Circuit went to a hard word count. For some people it's a challenge. Why don't I say Jen and then Jeff?
Hi, thank you, Your Honor.
Hi.
So I appreciate the work that people did on this and providing input in terms of the page count. I mean, we just internally, I asked all of our attorneys here in legal services and a number of our assigned counsel to submit word counts to me on 35-page briefs. Actually, they gave me 40. So my total sample size is 43 briefs that were recently filed. 25 of them were 35-page briefs. And 68% of them, so 17 came in well over 13,000. Most of them, 9 of them were over 14,000. There were only 8 that were under 13,000. And actually there were, of the 34-page briefs that I got for a sample, there were 6 of those and 3 of them were over 13,000. So from our standpoint, this is a pretty significant reduction in length, in brief length, that we are submitting to the court. And so that's of a pretty serious concern to us. I appreciate the comment about not wanting to increase the size and not make more work for the judges, but we are pretty regularly submitting briefs that are longer, much longer than 13,000 words.
Okay. Carl, did you want to have something you want to say back about that, or should I hear from Jeff first?
You can hear from Jeff first.
Okay. Jeff, go ahead.
Yeah, I know that the word count limit is a difficult one, and I know just from federal practice, for when they went to word count, it was originally 14,000. Several years ago, it was actually reduced, generally speaking, in the Federal Rules of Appellate Procedure to 13,000. It was actually quite controversial. A lot of appellate practitioners actually objected. And when the rule was changed, they let individual circuits keep 14,000 if they wanted by local rule. And so now we have a situation where, for example, the Second Circuit, where many of us file appellate briefs by local rule, went back to 14,000, even though probably about half the federal circuits are down to 13,000. I went to a recent brief that I did that basically was 35 pages and using all the kind of permissible formatting that's allowed under the rules, which is the 27 lines to the page, which, if you just did the normal word spacing in Microsoft Word, frankly, is less than that, but you can make adjustments to make it 27 lines for a fully double spaced page, as opposed, that is what a page that didn't have any footnotes or block quotes. You can see what it would look like. So not everyone's 35 pages is spaced the same way if they didn't adjust it to make 27 lines to the page. So a recent one I did came to roughly 13,250. Obviously, there's a lot of different briefs. Many of the briefs that are from pretrial dismissal come in under. The brief I'm talking about is one that was after a lengthy trial, a lot of facts, and we just, to make it really the best brief required us to go to that sort of, I'll call about 13,250. Now, obviously, you can ask for more words, but I don't know how well that would be received. The other thing is that once you start to play with words, just like people, we're always having to kind of deal with the page count, people will start to do things in our federal briefs where we have word counts. When you start to get a little desperate is maybe the word, you start to take out the space between the section sign and the number of the statute, for example, because the section sign, if you have a space, the way the Blue Book does it, is a word, but if it's attached to the number of the statute, it's not a word, things of that nature. So if you were to have something like 13,500, for example, people would then have the luxury of not having to play with things like that, which can get cumbersome, or if you're citing to Supreme S period and CT period for a Supreme Court case, closing up the space and things like that to make it one word. So I know reasonable minds differ, and everyone's concerned, and you do get a lot of briefs. I know that some of the fact-heavy trial court cases, I would have said 14,000. I think that's probably not realistic to ask in this context. Maybe 13,500 sounds odd, but I'm just throwing it out there to add to what Jen was saying. But we can learn to deal with whatever we need to deal with. I had a question about the reply briefs. You said that there was a typo for the Appellate brief. Should be not 14,000, but 13,000. Right now, you have the reply brief is 6,500. I actually like the idea of the reply brief being half of the principal brief. It is what it is in the federal rules. The federal rules, the reply brief is always half the words of the principal brief. This is against my own interest by even asking this question, but historically the 15 pages for the reply brief was less than half of the 35. And so I don't know whether that was a typo and whether you were really intending 6,000 or whether you're intending 6,500. But I would actually, before you change it back to 6,000 or whatever you're thinking, I would advocate, at least for the reply brief, particularly for 13,000 for the opening brief, that you keep it at half the words, like we have in federal appeals for the principal brief. And that may help a lot, even though we're supposed to be direct and succinct under the new rule that Dan Krish was talking about.
Carl, can you address that as well as whatever you were going to say?
Thank you, Your Honor. I just wanted to make sure that when we're counting words, we're just counting the words that are going to be included in the word count. We're not counting all of the table of cases and all the items before that. That's going to add a significant number of words, because I looked at 35 briefs and only 9 of them came in over actually the number is 9 of them came in over 12,792 words. When you just look at the brief and the footnotes, just the argument portion, not any of the initial stuff. So I might want to go back to your folks and see if they actually counted just that portion of the brief.
Okay.
And then in terms of what Jeff is talking about for the reply brief, I don't think that's a typo. That's the number I have on my separate list. So,
Jill, Paul, that's what we have. That's what was recommended.
Yeah, that's correct.
That's correct.
Yeah, I'll just make this comment. Any system, water's going to find its level. There are, folks who single space more than others to try to get, it's not so long ago I was doing what you all are doing, trying to get briefs in that comply with the rules. And so we'll, hopefully under both regimes, be it page, a page or word count, people will, keep in mind the person that's reading it. I always felt when I was advising people about, footnotes and block quotes and all. I mean, boy, you're begging somebody not to read that. I mean, just you're desperate for somebody not to read a block quote. And, because it's hard. It's hard reading. It's a hard sledding to get through it. And so, some of the things, I've heard, like people will start to use acronyms and all, and, maybe they will. If it makes it harder for me to understand what you're talking about, I would imagine it would be worth the words. But no doubt there'll be, I was as desperate as anybody to get under a word count in a tough case, but no case is like another either. And, we also have two courts. One of, at least under the system we have now, it's not always clear which court is going to end up with a case. And so that's an issue too, that we can't, as the circuits have, sort of have different rules for different courts. We don't always know where the criminal cases are going to end up. We don't know what cases are going to get transferred. And I don't think personally it's a good idea for people to have to refile briefs, except in the very unusual situation. It's costly, it's time consuming and all. So, we'll see. I mean, we certainly do want to work with folks. I don't think we want to be unfair about this. Carl, if folks have information that they can get you about, what's being filed, I think we'd be open to hearing about it. But this is sort of where the courts are. Is there a hand raise? Oh, by the way, I've been lowering your hands. If somehow you think that you still want it to be in the queue, don't worry about it. Just raise your hand again. I don't mean to cut you out. Claire, do you have your hand
my
up?
hand is, this is a new hand.
This is a new hand?
So, I guess I would echo what Jeff said in that, but I think 13,000 is fine. So let me just start where I come out on that. Though I think as I'm often the appellee, giving the appellee 14,000 would be fine also, and giving the appellant 13. But I will say that when you're writing for a word count brief, you're writing a different style. So you're not doing regional reporter citations. You shouldn't do that anyways. But even though it's not supposed to be in the rules, a lot of people still have regional reporters and everything's going to be tightened up, and there won't be a space between your section symbols or between, F-sups and all of that, because if you put any space in between, you become two words rather than one. It won't be the appellant and the appellee. It will be defendant, plaintiff, all your thes will come out. So it's a very different style. And you just adjust, and, you don't use long acronyms to describe, something you're going to repeat a lot. So I think it's going to be an adjustment. I will say for the amicus brief, I'm not sure why it's 4,000 words, because people are going to barely be able to clear their throat at 4,000 words. And why isn't that at 6,500 words the same as a reply brief? You have to ask for permission or be invited by the court to provide your views for an amicus brief. So it's not as though people are going to be willy-nilly filing amicus briefs here, there, and everywhere. But 4,000 is very few pages, and so I guess would propose
well,
that.
it was always 10, so it was always 2/3 of what a reply brief would be. So I'm not sure. I'm not sure how far off it would be from the usual.
But Claire, let me just respond to the first part of what you said, and those are all very fair comments, and it's going to be a lot of a readability issue for us. And we've got JTRs and people with and so if we get to the point where readability, because people are playing these manipulations to get under the word count, are making it difficult for us to read the briefs, we'll revisit that.
Yeah. Well, I mean, Judge Prescott, they do it in the Second Circuit now, and all of those, spacing things happen now in the Second Circuit, and the reason they happen is because if you're doing the word count just of your argument, just of your text, not of your other, not the table of authorities or table of contents, the automatic word processing programs, that's how they count. And no one's going to go out there and count them themselves. They're going to use the word processing counting system. And that's just the mechanisms of the case, is that they will, if you have a section symbol, a space, and then a number, that's 2 words. And if you take out the space, it's 1 word.
No, I get it. And just remember that this whole project and getting my colleagues to buy into it and understand it, it's a balance. And so part of that balance is not to be overwhelmed by long briefs, but also to make it readable on screens. And so it's a difficult balance, and we're just doing the best we can.
Nope, I got it. But I still would make the pitch for larger amici briefs.
Jeff? Is that a new hand?
Hi, yes. Yes, thank you. One is why try never to disagree with Claire ever. Actually, the amicus brief, I was actually pleased by the 4,000, and I'll tell you why. Because yes, currently reply briefs are 15 pages and the amicus briefs are 10. Which is succinct, and I've filed many amicus briefs, and it's an interesting challenge, but it actually helps you to do a true amicus brief and not just repeat the parties' arguments, to just get to the point, right? You don't have to have any exposition about facts or anything. If you take the 13,000 words, divide it by 35, which is the 35 pages, and you think about how many words per page that comes to, and you multiply that then by 10, which is the old amicus brief, you would actually come to about 3,715 words. It's about, and so 4,000 is actually a little bit more than you would get using the formula that the court has been using. It's actually sort of the equivalent of 10 3/4 pages compared to the 10 pages the amicus briefs are now. And obviously, I think that's nice that it's a little bit extra room than we actually have now. And you have to remember that the statement of interest of an amicus is a Roman numeral page under the current rules. It does, and even under the new rules that are being implemented, can be excluded from the word count. So people in your office have to remember to actually exclude the statement of interest of the amicus from the word count, and that actually helps quite a bit. The same thing comes when we get to the part of the extra words for if you have a state constitutional independent ground. That's the same as the amicus brief in terms of 400 words per page, as opposed to about 371 or so if you just strictly did the 13,000 divided by 35. So that's the other thing I wanted to mention, is that there's a reference here to reply briefs, again, being 6,500 words, and then the same thing for a cross appellant's reply brief, 6,500 words. Earlier in this meeting, we presented a new reply brief rule. This sort of came up, that refers there to 15 pages. And what we did in the old 67-3, what we went through earlier in this meeting, was to no longer repeat the page limit in the proposal that we went over earlier today. And instead of saying that the appellant may, within 20 days after the filing of the appellee's reply brief, file a reply brief that shall not exceed 15 pages, all of that came out. And it simply said the appellant may file a reply brief in accordance with section 67-5A. So I was going to, just for consistency, when we get to the reply brief and the cross appellant's reply brief here, not talk about the 20 days and the 6,500 words, but to simply, again, cross-reference to the fully enclosed, or whatever the right word is there, reply brief provision, which will then presumably have a word count in it. Obviously, that will have to be, there are going to be people with paper filing, so maybe you're going to have to play with the words to say, 6,500 words, or if it's a paper filing for somebody who doesn't have paper filing privileges, 15 pages. But the timing was also in the new reply brief rule, and it's just a cross-reference in 67-3. So I was going to say, propose the same thing for 67-3A. That's it.
Okay. Everybody have that needs it? You're keeping track, Colleen? Good, thank you. All right, anything else on those provisions? Thank you, all right. We're going to talk about the clerk's appendix next. Everything that's old is new again. We're going to go back to something many of us think of as familiar. And you know what, I should mention this. Judge Prescott, said that this is a balance, and we really appreciate the balance that the practitioners have had, both with the input you've given us, but also in sort of understanding our needs. I have been in government for a long time, not as long as some of you, longer than many of you. This is an instance where rarely does it happen where somebody in government comes to you and says, we can take on something new, or we can take on something else. And that's what happened when we were trying to figure out what to do with the hyperlinks. And all the clerk's office came to Paul and said, we can go back to doing these records, essentially. We're calling it something different. And I think that's going to make it easier for certainly us as judges, because I think it helps us get some of the other things we need from the e-file briefs, the hyperlinks especially. But as we're trying to relieve you all of certain burdens in exchange for some of the things we're asking of you, this is a big deal on our end, that they're going to commit staff time to doing this. So I'm gonna have Dave Gushtigian from our staff attorney's office sort of walk this out. But Judge Prescott, if you have anything to add to this before we go there, I think this is going to be a good thing for all of us, and the fact that they're willing to do it is a big deal for judicial and I hope for the practitioners. So Dave, you ready to go on this?
Yes, Your Honor. Thanks very much.
Put a lot of work into this, a lot of thought into this. Go ahead.
Thank you. My name is Dave Gushtigian. I'm in the staff attorney's office for the Supreme and Appellate Courts. As Justice Doria alluded to, everything that's old is becoming new again. So these proposed rules are based on the old yellow record rules that many of you most likely remember. For those of you that don't, the yellow record was put together by the clerk's office, and the idea was to have the key documents from the trial court in one place for ease of reference for the court and the parties when drafting their brief. And as Judge Prescott said before, this whole process has been a balance, and this is where it has ended up as far as the clerk's appendix has gone. There is not going to be a requirement that you hyperlink to the clerk's appendix. So just to give a general overview of the whole appendix, it will be prepared as soon as possible by the clerk's office, and the purpose, just as with the yellow record, is to have one place for all of the important documents from the trial court. The parties will have input on what will go into the clerk's appendix, but the intent was to allow the clerk's office the flexibility to use their discretion in a way that is most efficient for the courts and the parties. So these rules begin on page 28 of your packet. The first section, section 68.1, is the only section that is currently in the practice book right now. All the sections after this will be new. The main change from a practitioner point of view with section 68.1 is that the trial court will no longer be forwarding one complete copy of the case file in the scenarios listed in subsections B 1, 2, and 3. Everything's moving electronic, as is obvious from this discussion. So there's, after I believe Paul had some discussion with some other members of judicial and with the practitioners, and there wasn't a need to continue that practice. So you can see those have come out of the proposed rule. Moving on to section 68.2. This is the rule that discusses how the clerk is going to put the appendix together. After the appendix is compiled, the appellate clerk will upload it in a searchable PDF format to the case document system, case management system for access by the parties. Section 68.3 discusses what will go into the clerk's appendix. And as I said, the clerk's office will have the discretion to put in the appendix what they want, but in a prior rule, the section's escaping me right now. It's one of your preliminary papers that you're going to be filing early on in the appeal. The parties will be able to designate what documents from the trial court they think are important enough to be included in the clerk's appendix. So the clerk's office will look at that, but then they can also confer with the clerk of the trial court, and they're going to use their own discretion in order to put together the clerk's appendix. If you can see in section 68.3 there's some guidance as to things that are not appropriate for the clerk's appendix, such as transcripts, which, as Renee previously touched on, would be put into the party appendix. Just going through these sections. You can feel free to stop me if you have any questions or if there's anything you'd like to discuss, but I'll just keep marching through and then we can go back once everyone's had a chance to formulate any questions that they have. Section 68.5, 68, and 68.6 is another extension of the clerk's office discretion. If there's more than one appeal taken from the same trial court docket number, then the clerk's office has the discretion to just put one clerk's appendix together and not one corresponding to each docket number. And similarly, in the next section, they can prepare only one clerk's appendix when there's several cases that present the same question. An example of this that I thought of was the racial disparity in death penalty cases, where you had docket numbers from all over the state, but they raised the common issues, so it would be most efficient to just prepare one clerk appendix in that type of situation. As you can see in section 68.8, the clerk's appendix may be supplemented as needed. For example, if there's a motion for an articulation or a rectification that later needs to be included in the clerk's appendix, that can be uploaded as a supplement. 68.9, just to briefly explain why this wasn't included, but it was previously included as part of the yellow record. We included the substance of that section into section 68.3 that talks about the contents of the appendix. So that's why that section's removed. With respect to section 68.10, that governs the clerk appendix in administrative appeals. We've changed, you won't see it reflected in this draft because these are entirely new rules at this point, but we changed the language a little bit just for clarity. I don't think there was any substantive changes to this part, but it's a little different than it was previously. And actually, yes, okay, yes, it was different than previously. But that's just a general overview of this chapter, and I'm happy to answer any questions, give some insight on some of the choices that we made in drafting it.
Thanks, Dave. Giovanna?
Thank you, Your Honor.
Everybody could mute their microphones so we don't have the echo.
Thank you, Your Honor. I'm not sure, Dave, you covered it. My question was on page 20. It's the section 63-4 additional papers to be filed. And my question is on the new subsection 4 on page 20, 4D. And again, Your Honor, I don't know if this is a different bucket, and maybe I'm getting ahead, or if I could raise the question now. My only question is, I see on 4D for Rule 63-4, it says whether there were exhibits in the trial court, but when we get to new business, the proposed new language will have something along the lines of whether there were exhibits in the trial court, and if so, whether the exhibits were physical, electronic, or a combination of physical and electronic. And so my only suggestion is that, or as maybe a placeholder, that you insert that same language here so that it would be consistent with the new Rule 63-4 if that gets amended and adopted before these get put into place.
You're muted, Your Honor.
Sorry about that. Dave, if you have something to respond to that, that's fine. But otherwise, Renee, this might be your bucket.
Yeah, I can tell you that the reason, so 2 things. First, you are correct. We should put that into this proposal as a placeholder. But I can also tell you we have it separate because the trial courts have already started using electronic exhibits. So we want to try to get that rule, if adopted, about including the electronic exhibit information in the docketing statement. We want that to go into effect as soon as possible if it's adopted. So it's likely that it would become effective prior to the e-briefing rules would become effective. So we do have them as 2 separate proposals, but if the one about electronic exhibits is adopted, we should put it in our proposal regarding the preliminary designation of the pleading. Well, what we're now calling, or we used to call, the preliminary designation of the pleading. We should put it in there as a placeholder.
Okay, that's a good catch.
And then, Your Honor, just a quick comment and a general question. My comment is, I think this is terrific, and I really appreciate the work. And I went and looked at the new fonts, and I really like them. So I thought this was just so much good work. My question is there going to be like an educational component that goes with this? Like, will Renee and Dave and others be going out to bar associations or accept invitations to firms to come and talk to us and make sure the practitioners all know about the new electronic filing rules?
Oh, you want to talk to that?
Yeah, I mean, I think there's, I think we always want to provide information when we can, and we're happy to do whether we set it up, virtually but we can certainly, we did that with e-filing. We've done it with briefs in the past. I remember addressing, the Chief State's Attorney's Office and the PDs. So sure, absolutely, we will be happy to do that.
Thank you, Paul. I'll hold you to it.
You got it.
Anyone else? Okay. Anything else you need to add on that, Dave, or you seem to?
No, I mean, I think the major concern with the old yellow record was that it was delaying the processing of appeals. But the clerk's office is well aware of that, and the intent of this is to have the clerk's appendix uploaded as soon as possible after the appeal is filed.
Yeah, we want the appellant to be able to cite to the clerk's appendix in their brief.
Absolutely, Your Honor. Yes.
Jeff Babin?
Yes. Hi. So a few things. One is we recently had a meeting of the Connecticut Bar Association Appellate Advocacy Section. We understood that new rules were going to be coming into place, in part because which we're going to be getting to some of the suggestions on the petitions for certification, for example, came from a subcommittee of that section of the appellate section. Linda Morgan had suggested that we put together a CLE after all these new rules go into place and ask for volunteers. And I know myself and Jay Sexton volunteered to Linda. So maybe that we could coordinate and have some type of CLE that would then have a few practitioners and some people from the clerk's office kind of do a kind of a joint thing from everyone's perspective. So I just wanted to throw that out as a resource for you all. In addition, if I look back at this, I'm sorry, I have to find my place. So my understanding is that we've been talking about the clerk appendix as essentially similar to what was the old yellow prepared record. But of course, when that became the appendix part 1 was the original successor to the yellow prepared record. And the part 2 was essentially what we're now talking about as the party appendix. So in effect, we're going back to the yellow record, which was the part 1, to have the clerk have some control over it. Over time, the rules under 67-8 included some content as to what would be in the part 1 appendix. And over time, this committee has advised on various changes to that, and they've been adopted, and therefore actually has specific content. Like, for example, I think in the last year, the rules were amended to say, for example, the operative complaint, as well as things like other complaints at issue, motions, opinions and decisions, and of course the judgment file, which we can talk about in a second. My only concern is that the new rule under 68-3 says clerk appendix contents, but says what is not to be included, but doesn't say what it is to be included. Later, under 68-10, it does say what is to be included for administrative appeals. And under 68-11, which on page 33 of our packet, it says that it has to include the written decision that is the subject of the appeal. But all the language that we had previously for part 1, and in fact we made amendments to make sure it's there, about the operative complaint, other complaints at issue, motions, requests, findings. I don't know if we need findings anymore. I'm not quite sure what that even refers to. Is gone. And under 63-4, which we didn't get to yet in Dave's presentation, we skipped over that. On page 18, it says that we are to designate in our 63-4 papers what should be in the clerk's appendix, but now all content other than administrative appeals and the trial court's decision is gone. So there's no guidance anymore as to what should be in there. So my proposal is that either in the 63-4, it gives guidance as to what should be designated, or in 68-3, entitled Clerk Appendix Contents, we give that guidance. And then in 63-4, it should refer to, let me find that back on page 18. It says that we should designate the documents docket in the case file which we deem necessary to include in the appendix, and then maybe it should have some reference to in accordance with 68-3, and then put that into 68-3, because right now it's essentially contentless. I mean, it doesn't say no memorandum of law. It doesn't have any of the kinds of things that we've worked on part 1 over the years to kind of keep it under control. And then the only other thing I had, and this is kind of more minor, under 68-10 on administrative appeals, there's some language which maybe hold over to some earlier era, where in addition to what the appellate clerk finds is necessary for the proper presentation of the issues in an administrative appeal in the clerk's appendix, it also talks about what the judge who tried the case directs to be included or shall order included. And that's in two places in that paragraph. And I'm not sure if we're going to, I'm not sure what the mechanism is where say the presiding judge in New Britain on administrative appeals would ever be ordering or giving directions as to what's going to be in the clerk's appendix in the appellate court, or how that would even work and why we would even go to that judge, which I think is currently Judge Clow. It's been Judge Cohn, Judge Huddleston in the past. So I wasn't sure if that language really should be included in the two places where it's referred to there. And sorry, at the very end of the paragraph under 68-10 subsection A, the last sentence of it, it refers to relevant portions of the record before the agency returned by to the trial court but not included in the clerk's appendix should be reproduced in the party or appendix as provided in 67-8. I think that should be in the brief or party appendix. It just says appendix. Okay.
Okay. On the handful of issues that Jeff's brought up, do we have anybody from Paul that I have one question I had before we get into some of this, but in the old rules about the printed record, did we have something that listed, is that what you said, Jeff, that we did have it in those old rules under what I used to think of, and I still only know the old rule numbers, 4013. I never learned the new ones.
Oh,
but
yes.
When you were designating pleadings or when the clerk was assembling the printed record, did we have that kind of guidance? Or did it just know?
So
that was my thought, was that the reason we started putting that stuff in the part one was because practitioners didn't necessarily know what needed to be in part one. Whereas between the parties and, I mean, the clerk sort of, we assume, comes to this with a basis of knowledge, and the parties know what to designate, and the clerk will otherwise, look through the record and determine what needs to go in. Does anybody remember if the old rules used to apply to this? Is that why you raised your hand, Dave? Go ahead.
Yes, Your Honor, I have the rule from 2016 right here, if you'd like it. I can just read the first sentence briefly. This is the old section 68.3. It's titled Record Contents. The appellate clerk, in preparing the record, must study the case with sufficient care, must study the revised designation of specific pleadings submitted pursuant to section 63.4A2, and the brief of the appellant, and it used to be the record was prepared after the appellant's brief came in, and may confer with counsel and, if necessary, with the clerk of the trial court to determine what part of the case file should become the record. And then it goes on to say what should not be included. But that's where we started, was with these old record rules. And I suggested taking out some of the study the case with sufficient care and study the revised, and just kind of left it to.
Yeah, we can't have that.
The clerk should prepare the clerk appendix, and less is more was our thinking on that.
May I just ask whether 63-4, where it referred to what you had to designate for the prepared record, had any guidance in that old practice book?
I only have the chapter 68. I don't have any of the other chapters in front of me. But because Carl may be able to help us.
Anybody know? Carl may be efforting this as we speak. Is that?
Carl's in the office, so he may have access to some of the old books while we're in the meeting. But I did go to the last time the designation of pleadings appeared in 63-4 in order to get our base language to work from. And no, it did not delineate a list of the particular types of documents like we currently have in the appendix part 1. I don't think that we had a specified list like that anywhere. in the rules when we were doing the records.
Just a story, it's Paul, if I may.
Yep.
Having done probably 10,000 records, designations came in all shapes and sizes. Some just said everything, and some would actually list out documents. So I can tell you that there was no specifics required that I recall.
Okay. Carl, what do you got?
Well, I have a practice book from 2013, and that in the designation in 63.4 simply states that a preliminary designation of the specific pleadings in the trial court case file, which the appellant deems necessary to include, including their dates and filings, the trial court, and if applicable, the number as listed on the doc sheet. So it just says how to identify the document. It doesn't say what documents are to be included.
Okay.
So
I'm sorry, go ahead.
I mean, not necessarily related to the rule, but this is going to be really important if we're going to be preparing clerk's appendix based on your designation. I think it's a very good point that Jeff raised.
Okay.
Let me put my hand up here if I know. Let me see. There it is.
Paul, go ahead.
Thank you, Justice Doria. So I see my hand still up. I'm not that technologically good at this. So the idea here is, since this, and I agree with Jeff, I think if we can give more guidance, that would certainly be helpful for everybody. I think because this is being prepared in advance, and we know issues can change as you begin to brief these cases, the idea here is to give the clerk a fair amount of latitude, and the guidance is going to be in the clerk's office is to consult with counsel, to work with counsel, so that clerk's appendix is helpful to the bench and to counsel. So the idea is to allow the rule to give the clerk wide latitude, and again, working in conjunction. I prepared records before briefs came in, and I prepared them after briefs came in. It was a lot easier to prepare them after the brief came in. So I think to your point, Jeff, I think any kind of further guidance we can give in the rule would certainly be helpful. But I certainly don't think the clerk should be restricted in terms of their preparation.
What about the point that Jeff makes about the administrative appeals, and what and who does the designations?
Looks like Judge Prescott's.
So I've been the PJ in the administrative appeals docket in New Britain myself. No one ever asked me, either from the appellate clerk's office or counsel, consulted me on it. I don't think it's necessary.
Okay. Any other comments on this bucket of rules? And maybe we can come back to how we're going to fashion any amendments to that. Okay. Without any, I do want to mention that there's one other set of rules that kind of that got 67.2 is a little bit out of order. Just the sequencing of it, that's in the middle of all this list of things, has to do with the format of the briefs. I don't know that anybody's really talked that through, but Renee, is there a quick summary of what you think that you can give everybody, or folks have had an opportunity to review it, I hope, but what we're accomplishing there?
Yeah, so what we're wanting to do is have the folks that will still be filing paper briefs, which will mostly be inmates, but we do get people who get exclusions from electronic filing that are otherwise able to do certain things with the computer and typing things up. So we want the briefs that will still be paper, to the extent possible, to sort of look like the electronic briefs. because those of us in the clerk's office, when we have a case with a paper filer and we receive the brief and any appendix from them, we scan them and upload them into our database and provide an electronic version to the courts. So they won't have much of the other, usability or the tools that we're having to include, like the bookmarks and the internal hyperlinks and things of that nature. But the changes to the paper version for 67-2 are just to try to make those paper briefs look a little bit more like the electronic versions. So I believe we eliminated the color covers, and we eliminated I'm having trouble remembering the specific things. I think we changed the font. We may have changed the spacing. We had them do the page numbering the same as we're doing with electronic briefs, and the margins, things like that. So those are the kinds of changes we made for the paper filers. There's nothing else substantive about what the paper filers are required to include in their brief or any optional appendix that they file. It's just some formatting stuff to the extent we can have those briefs look a little bit more like the e-briefs once we upload them.
Okay. Anybody else want to be heard here? Jeff?
So just one very minor technical point on page 24 of the packet, where the color of the front cover is removed from the rules. It just now says a suitable front cover of heavy paper. I was going to suggest that you add the word white, that you have a suitable front cover of white heavy paper, since you do specify white for the back and you're no longer having a color front. So that was just a thought.
Okay.
I mean, I would be fine with that change if the group is okay with that change.
Okay. Anyone else? Okay. What I think we should do, I think there are enough changes here that, in 24 hours or so, we could kind of collate them and get them back out to folks. And I'd like to call for an email vote, if possible, for this whole batch of what's under 1C. Renee?
Yeah, since we are wrapping up the e-briefing rules, there was just one rule change that we did not address in our discussion that I just wanted to make sure everyone noticed. And we did mention during the discussion of the clerk's appendix about it being done prior to the appellant's brief. And in 67-3A, where we had the discussion about the word count, in that rule is also an update to the timing of the due date for the appellant's brief. And so I just wanted to make sure everyone saw that, that the time for filing the appellant's brief, the original due date for the appellant's brief, will now be connected to the transcripts or the clerk's delivery of the clerk's appendix to the parties. So the uploading it to our system so that autumn notice goes out to the parties, whichever occurs later. So if we do have a circumstance in which a party already has their transcripts, or they get them quickly and the clerk hasn't had the opportunity to complete the appendix yet, the onus won't be on the party to file an extension. Their due date will then be set based on when our office is able to provide the clerk's appendix. I just want to make sure everybody saw that.
Okay. All right, thanks. I want to ask Paul and Jill what they think, but I'm respectful of people's time. We're past 2 hours at this point, and I'd like to try to touch some of the new business. I think, especially in light of what the input that Jeff had at the end there, what might require a little bit of finding the guidance that we want to give. I think my suggestion, and I think Judge Prescott agrees, is that we could wordsmith what we needed to do and make some changes and send this all out to the group Jill, do you see a problem with doing that way? And get,
I don't see any problem doing that.
we'd like to, and we'll give you, sort of a date if you guys, if you all could get back to us with a vote on it so that we could, submit these rules to the court. Well, we're moving towards a public hearing first. So obviously, the bar and the public and the folks on the screen obviously could still be heard on all of this, but we'd like to jump through that hoop. So why don't we do that? Anything I need to other housekeeping on that issue, Jill or Paul?
I think just to the members of the committee, I mean, we'll work on this, but we may be reaching out to some of you for some of your input as well as we go through this to try to just get this as tight as we can.
And do one more thing. Once we do get it out to the committee, I know everybody is very, very busy, but now if we are going to try to get it on to the a public hearing in May, we will give a pretty quick turnaround for comments and vote because we need to get it ready for publication in the Law Journal.
Okay. So that we'll go on to new business 2A. Renee, in light of what the exchange you had with Giovanna earlier, what's our pleasure at this point? We're talking about pages 34 to 36, about 63-4.
Are you referring to the new
trial exhibits, or whether they're physical or not?
Yeah. So if everyone approves of the language that we've included on page, I believe the actual language is on 35, to have it included in the docketing statement, whether or not there were any electronic exhibits, then I think what we would do if it's approved is then in the proposal that brings in the designation of pleadings, we would just update this particular is subsection, I think it'll be 4 in that proposal, to include this information about the electronic exhibits. And I think that answered Giovanna's question.
Okay. So do we need a motion of any sort at this point?
Yes, I think you do.
Okay. Do we have one?
So moved.
Anyone? So moved.
Claire
moved.
Kindle.
We have a
Charlie
second.
Gray, second.
All those in favor?
Aye.
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 Any opposed? Okay, that passes. This next item, 2B, this is something that Judge Keller has had since she got here, a question about, and she immediately sort of asked, why on petitions for certification do we not get a position from the child's attorney? Jen Bourne, is this something that you supervise, or is this just something your office? So it's just your office does this still, right? You don't have anything to do with the children's briefs?
No, there's a separate child protection unit that handles the appeals for these issues.
Yep. So I guess, Jill, I mean, it's now just sort of occurring to me, if this is an imposition on someone, do we have the right person in the committee to speak to making sure that we're getting some from the minor children?
I mean, we could mark it over and find the appropriate person, somebody else who has more of an interest.
Would it be Sue Hamilton? Yeah, Jen
Yes.
shaking her head, yes. Yeah.
We could do
All
that.
right. Let me ask, does anybody else that we have on the committee, I mean, Claire, you've got the child protection cases you handle for DCF. but I'm not sure that there's anybody else that this impacts. Am I wrong about that? Can anybody think of anyone?
I think it would just be Child Protection Matters. We think it's a great idea. We think that the the guardian ad litem's representatives should be weighing in more with respect to appeals and petitions for cert. So,
okay,
but it's not our burden, so
I
we
mean,
can't.
I don't want to lose 6 months on this, but if it's something that's important to folks here on this court, it's a Supreme Court issue. It's not anything that. So Jill, why don't we talk about whether there's something else, like maybe I should ahead of time to facilitate this. Okay, and I think the final item on the agenda has to do with the form of petitions for certification. This is a proposal that I know has been under some consideration for a little while. I guess the CBA has brought this, the appellate section. Is somebody deputized to sort of talk about this from the committee, whatever we used to call it? Jesse? Oh, yeah, sure. Jesse, of course.
Yes, Your Honor. I am a co-chair of the CBA.
Right.
So as you know, this came from exchanges between the section and various justices who had spoken to the section regarding petitions for certification and frustrations on the part of the bar with respect to the current rules and the formatting of petitions. So the section was invited to submit a proposal as to potential amendments that could be made to the rule so as to better facilitate the format that would allow the petitioners to maximize what was given to them in order to make their best case for certification. And so there was a subcommittee headed by Linda Morgan and Jeff Gentis, and I believe several other members participated, and they came up with this proposal, and that's what we have before us right now.
Okay, good. And any comments? I mean, I think this is a good thing. I think we're, I mean, this is, again, a uniquely Supreme Court issue on the certifications, the petitions, but we would, we're in favor of anything that makes you able to maximize your space. I think we can always tinker with the format. There's no magic to it. No one else? I will, before we sort of vote. Oh, go ahead, Jeff.
I'm sorry, just a quick question came to mind, which I hadn't thought of earlier, but since we're moving to word count on briefs, it occurred to me that, for example, in the federal system, they also ultimately moved to word counts for motions as well. I'm assuming that that is not in the works, that for motions and petitions, it's still going to be the old rules. We're going to have, the 10 pages, same old margins, Arial typeface, et cetera, et cetera.
Yeah, Paul, Jill, what do you think? I think we're not changing those rules right now, but
we're not changing those rules right now. I think that's not too far off. That would be what I would say right now, but we're not there yet.
Yeah, we've talked about it, Jeff. It's coming at some point.
Okay.
Before I bring it to a vote, if anybody else has anything to say, let me. Oh, Charlie, go ahead.
I'm in 84-5 A3. And as I sit here and I keep reading this thing, I'm having trouble thinking of a situation in where it would not be applicable, or where a specific description of how the appellate court decided the question would not be applicable, which makes me question the inclusion of the word applicable. And so, I may just not be conjuring up the right situation, but I question the inclusion of the word applicable in a petition for certification from a judgment of the appellate court.
Any thoughts?
I think it's probably when the appellate court dismisses an appeal summarily, and so there's nothing to talk about other than it was summarily dismissed.
Okay, fair enough.
Okay. One thing that's not we're not including in this, this was the CBA's thing, but maybe coming attractions on forms of petitions. And I would appreciate your thoughts on it, everybody's thoughts on it. Is I think it would be useful to give some consideration to what's the best, I can tell you from my personal experience, what's the best appellate court version of the appellate court decision to attach. We get them in, and we accept them in all different forms. Maybe especially as all of this is e-filed and it's most everything is available online. I hope it's not a heavy lift for anyone if we wanted to standardize it in any fashion. My preference, and I think most people's preference, is something that has the footnotes at the bottom of the page and not at the end. I read the footnotes, and so what's that? The Law Journal is probably the best. Maybe that's because I've been doing it for 30 years, and I see what the law speaks to me, how it lays out on a page. I know there are some things like Westlaw that do have footnotes within the text, but they appear sort of differently. Unfortunately, our judicial website version is probably the worst. It cuts off the last line a lot of times, and then the footnotes are at the end. But I totally get the fact that sometimes an official publication is not available in the time that you need to move. Certainly we're guilty of that. We've been doing slip opinions for a while. So it doesn't have to go into this proposal, and I'm going to ask for a vote on this anyway, but I would appreciate some thought given to, does it matter to any of you? Does it matter? If we standardized it in some fashion or had, one of these two versions, I hesitate to say Westlaw. People don't all have Westlaw. And this may not even be the whole crowd that I need to be speaking to. The folks that don't routinely do appeals, what they have access to, easiest access to, is it needs to be considered as well. But from a readability standpoint, given that you're always looking at the appellate court decision, that some of them are challenging. Some of the formats you get are just challenging to make sure you absorb all of it. So, but with that being said, Charlie, do you have your hand back up, or did I forget to put it down?
Nope, I'm set. Thank you.
Okay, great. So then do we have a motion on the CBA's proposal on the forms of the petitions?
Jeff Babin, so moved to approve.
And a second? Did anybody second that?
I'm Giovanna Weller. I'll second.
Okay, thanks. And all those in favor?
Aye.
Aye.
Any opposed? All right. So that's all set. Anything else before, and we'll let everybody go. Appreciate your patience. This was kind of a long meeting, but this was one of our more important ones that we'll slug it out through. Judge Prescott, you all set?
No, just if you can get back to us when it's time to vote as quickly as you can, because there is a time crunch.
Okay, with that, we'll adjourn. Paul or Jill, we're good?
Yeah, yes, we're good. We'll be contacting some of the members of the committee probably as soon as tomorrow.
Okay, well, thank you all. Appreciate it.